Welcome back to the Pacific Stage. Thank you so much for joining us for our last session of the day. It is called 10 Mistakes Producers Commonly Make in Clearing Their Chain of Title. It is my pleasure to introduce our presenter, partner at Pryor Cashman, LLP, Karen M. Robson. Thank you so much, Karen.
Thank you. Hi, everybody. Now, this is not my first time presenting at a conference, needless to say, but it certainly is my first time presenting in this format. So bear with me if I'm, a little bit awkward or don't answer your questions exactly right. But I'm going to just launch into it. First of all, I'm going to say, as Aaron introduced me, I am a lawyer. I am a partner at the firm of Pryor Cashman, which is a US law firm with headquarters in New York City, where I was for many years, and with an office in Los Angeles, which I started also quite a few years ago, and an office in Miami. I'm a film and television, audiovisual related entertainment attorney. I work in a kind of corporate hybrid entertainment financing distribution. But one area I love is chain of title. And so today I'm talking about 10 mistakes producers commonly make in clearing their chain of title. And I did share just a list of these 10 mistakes, as it were. There are probably more, but everyone loves lists of 10. It's very internet. And I'm going to start with what is chain of title. Most of you are going to know or have heard that term before, but really it's about ownership of the rights to make a motion picture or television program or audiovisual work. You're all familiar with the concept probably of title. When you buy a car, you have to actually register it with the motor vehicles, the Department of Motor Vehicles, and you get a little certificate saying it's registered. Maybe you also know it if you've ever bought a piece of real estate or a house or an apartment or what have you, that there's a whole process for registering it. Now, in the case of chain of title of movies, it's a general concept about ownership, and it's about how do you prove to somebody in particular, you need to prove it to, or to the world, that you own all the rights to make your, let's call it a motion picture, could be a television program or in some other form of audiovisual work. And when I'm talking about mistakes, I'm talking from a producer's point of view. And of course, a producer can get involved in a project at an early stage, a development stage, or a producer can come in towards the end and acquire something that somebody else has developed over many, many years and acquire it, option it, buy it, and then try and make it. And the chain of title may be more developed if you come in later on. So what is chain of title? It is really, if you think of a chain, it is in fact the links of the chain. And so what you are trying to show to people that you have sometimes called clear chain of title, sometimes called clean chain of title. Some, people refer to it in different ways, but it is basically that you own all the rights necessary to make your project, and nobody else seems to own any rights that could conflict with your rights or interfere with your rights in any way, shape, or form. Who are the people that you will be trying to need to show this to? For sure, it will be any financiers of your film. It will be banks, other forms of financiers, private investors. All of those people will want to see that you have and ask you to show them the chain of title. And other people who will need to know it are the guilds or unions. SAG-AFTRA in particular will ask you for a detailed chain of title. And the reason they want to know, because they're going to file security interests against it. Governmental Organizations who are offering you tax credits or grants might also want to know, may also demand to know that the entity, perhaps based in their state or country, owns the chain of title. And then, of course, the other people who really want to know are the distributors and licensees that you will sell it to, ultimately, perhaps pre-sell it to before you make it, and certainly afterwards. The completion bonder, if you have one, is going to want to know, and the insurers are going to want to know. So there are a lot of people, and you're going to want to know because you don't want to get sued by somebody who says you don't own the rights. Now, it's interesting because the detail in your chain of title, the amount of evidence and proof that you own everything and nobody else owns it, is going to differ a little, is going to differ a little depending who you're presenting to, and frankly, who their lawyers are. Some lawyers are just incredible pains about chain of title. Others will basically, as long as you have all the links and it's all registered, will be fine. So the first mistake that we're going to talk about is a failure to organize and review essential chain of titles at the initial acquisition of the project. And the reason I say that's a failure that producers make is a lot of the time people are very excited to acquire it. They focus on the main like script or whatever it is that they're buying. They start their lawyers negotiating to acquire their property, but they don't go through the process of actually having someone, I mean, hopefully the producer themselves can start with the basic information. Now, first of all, it does depend a little how complicated it is. I mean, you may be lucky and have a very simple chain of title. As the simplest chain of title is one original screenplay, not based on anything else, that you are acquiring directly from the author, and you are acquiring an assignment of all rights, all copyright, all rights that are available in that chain of title, and your company is acquiring it. If you're doing that, it's incredibly simple, and you will just need to make sure that the screenplay is registered, sign an agreement of signing it, make sure your assignment is filed, and so on and so forth. But most chain of titles is a little more complicated than that. So firstly, you should just ask the person you're acquiring it, particularly if it's another producer, for chain of title. Sometimes they'll give it to you in a very confused and messy way. You can at least ask them to index it for you and give you a chain of title memo. If they don't, you're going to have to organize it and you're going to have to put it in order. Chain of title is going to start from the origin document or work, and it's going to go all the way down to the person you're acquiring it from. And hopefully they can do a memo for you, and you can, and then they're going to give you copies of all of the agreements. If it is a complicated chain of title and you foresee problems, you're going to want to order or ask them to provide you with a copyright and title report from the US Copyright Office that will show you what has been registered and may flush out some issues. There are other reports you can obtain called UCC or lien reports, bankruptcy searches, litigation searches. Those sort of things aren't usually ordered early on unless you feel or you know that there are problems. When you know there are problems or issues, you're going to have to do a lot more on this, but you should just start with a basic chain of title. If you get a copyright report, you're going to compare your list of documents to what turns up on the copyright register, and you're going to try and match them up. And they're not always going to match up. Maybe your list of documents, you're going to have more links because people didn't record them. If there's something recorded in the Copyright Office that's not in your list, that is going to require your attention. And if there are things in your chain of title that are not registered or recorded in the US Copyright Office, you're going to want to do that. Just a little hint here. is, if you are acquiring chain of title, you're going to want to make approval of the chain of title in your option or acquisition agreement a condition precedent to you having to pay for the rights. Because what you don't want is to buy the rights, then find out, pay them a lot of money or a little money or whatever's a lot to you, and then find you've got problems. I mean, sure, they might then be in breach of their contract, but that's not where you want to be. You really, ideally, you would do it before you even enter into an agreement, but sometimes people don't want to spend the time or money with their lawyers to do that. If they think everything's fine, enter into an agreement and have a condition that you get to approve it before you have to pay them. Then you're going to have to read very carefully every document in that chain of title, or hire a lawyer, better if you can afford to read it. This is sort of the basis of chain of title, so it's not so much a mistake, but it's more like you need to read them very carefully and make notes of everything. I'm going to run through just a few things that you'll be looking for in them, and then we'll move on to the next mistake, as it was. All right, so you're going to look at a document and you're going to see what work it refers to. For example, if this is a chain of title that starts with, say, a novel, the first agreement is going to be about acquiring the rights to make that novel into a film. And it might also be the actual details of the publisher of that novel. So you want to know, what that work is, when it was created and published. That's going to be relevant, something we talk about later. If it's a script or something of that nature, you're going to want to know if it was a work for hire, which is a concept under US copyright. Basically, if it was a script and the script writer wrote it for Warner Brothers, it'll be a work for hire for Warner Brothers, and you'll be acquiring it from Warner Brothers. You're going to look for certain clauses that everyone who's going to review the chain of title would like to be in there, such as waiver of injunctive relief. I don't know if you know that, but equitable remedies. That's a clause that says, you can sue for damages if I produce or breach this agreement, but you cannot terminate the agreement. You cannot sue to enjoin the distribution of my film. You're going to look to see if there are short forms that can be filed. And if they're not, maybe you want to create them. That's just like a little summary version that you can file in the Copyright Office, so you don't have to file the big document that you're acquiring the rights in, because you might not want everybody to know all the details of that. And the most important thing you're then going to look at is what rights are granted in that document. So obviously you're looking for as broad a rights as possible. And, is the grant broad enough to do what you wanted to do? Is it worldwide, every language, sequels, remakes, everything? Or is it narrower? And that's okay. You've worked out how that can be done, but you just really need to know what's the territory, what's the term, is it an option, is it an outright buyout? Is there a reversion? Like if you don't make the film within a certain period of time, will the rights go back? Is there provisions for remakes and sequels? How do they get triggered? And then what reserved rights? Has anybody reserved any rights? Usually when you acquire rights in a novel as the basis, or a novel is in the chain, there are going to be reserved rights. At a minimum, the print publications and text rights of those books. So that's the kind of thing you're looking for. Mistake number 2 on my list is sort of related. 2 and 3 are really related to this. Failure to have an experienced lawyer review the copyright and other reports carefully. And if necessary, you might need to actually obtain a copyright opinion. Now, this is really only because lay people can't necessarily have the experience to read those copyright reports. And what you're looking for is any breaks in the chain, or any person who has rights who's retained rights. You're also looking for security agreements and mortgages of copyright, because sometimes This is not going to be that common if it's a brand new work, but it might exist, particularly if there was a prior film. But it could exist even in a new work, because somebody perhaps invested the money to develop it and they got a security interest of some kind, and that is filed. And you really need to look out for those and consult a lawyer, because they will need to be removed by a termination. And often you'll see a security interest and then you'll see later in the report termination, meaning it was ended. And sometimes those things are just there and nobody's bothered to terminate them, and you can get them terminated. And sometimes they're there for a reason. They can't be terminated without a settlement of some kind. Then we're going to talk about Section 203 of the Copyright Act, which gives authors and their heirs rights to terminate. You're looking for those two. And I think that, I will just give you a story from, I've had, in the last few years, I've had situations where clients have negotiated extensively an acquisition agreement. Then they've looked at the copyright report. I've had one, frankly, when there was a copyright opinion, but they failed to notice that there was not only a short form option previously, but there was a short form assignment filed. And everyone just thought, oh, that must be a mistake. It's been optioned before and what have you. Turned out it was not a mistake. The option was, in fact, exercised. In this case, it was by MGM 20 years ago. And they, in fact, had rights. And so you really have to read those carefully. You can't just assume things are mistakes. So that's that one. And then the number 3 is really a further extension of that. And that's when you're looking at the chain of title and when you have options, and when you have options that have gone on for a long time on novels and things of that nature that underline maybe there were previous owners, you're going to ask for evidence of extension of the option, copies of wire instructions or payments, and you're going to try and match them up and make sure they were properly extended. And if they weren't, you can ask the person you're acquiring it to go back to the owner of the copyright, who hopefully is friendly, and get them to sign an acknowledgement that all the payments were timely made. Just fix these things now when it's not going to cost you a fortune. Also, I've had some problems with old chain of title where the documents you have are missing pages. They're badly Xeroxed. They are missing signatures. This is actually very ugly. And, proof of payment and acknowledgement of payment are things you're looking for. You're also, in reading them, you're looking to see, does it refer to another agreement, but you don't have a copy of that agreement? Then you're going to ask them for a copy of that agreement. Now, if I'm really freaking you out, we're going to move on to 4, which is something completely different. But I also want to say, when there are problems in chain of title, there are often solutions. Sometimes the solutions are getting an opinion. I'm going to talk about some of the solutions later on too. Very few old chain of title documents are perfect. I've worked with many that are not perfect, and we find ways to convince the people we're making the film with, the financiers, the distributors, that they are satisfactory, sufficiently satisfactory. And frankly, we want them to be too, because the producer does not want to be sued either. So there are, even though I'm telling you that you need every T crossed and I dotted, I'm really saying that even if they're not, it's good to know what you don't have, and then see what solutions you can apply early on, and then work out how you're going to, solve the other problems. Mistake number 4 is something that doesn't happen so much, but is really interesting to me. Just notice if you have any foreign works, when foreign meaning non-US works, or material in your chain of title, like a French novel, it was based on it, or you have any foreign law contracts in the chain of title, because the law outside the US is quite different, particularly in continental Europe. And, I've had a lot of cases where there are works from France. If your project is based on, say, a French or Italian motion picture, you're going to, unfortunately, need to get a French or Italian lawyer involved, because what you would normally do in the US is not necessarily what has to be done in France. It's very interesting that in France, even though a producer of a film might control the economic rights relating to that film, if you're trying to acquire the right to make a film based on that film, you may in fact need the rights of a lot of other people as well, the director, the composer, the screenwriter, etc. Maybe the producer can organize that for you, but you'll probably need the advice of a foreign lawyer. Another approach can be, sometimes if you really want to do something based on an international work, is partner with an international producer based in that country who is familiar with that, who have their own lawyer, who can help obtain the, advice that you need. But another thing, this concept of work for hire that we have in the US, where if you're a production company and you produce a film, you have everybody sign work for hire agreements, and you own the copyright of the film, and you own all the results and proceeds of all of those people's services, is not a concept that exists in many other countries. And therefore, there's also other rights like moral rights that you've probably heard of, or droit moral in French, which, they may have other rights, which if you're obtaining rights in a film. And I've had some super interesting cases over the years where, a client came, said, we're going to get the right to remake this American film. Once we looked into it, we found the American film was based on a French film. The French film was based on a novel that was based on a play. And so it was a way more complicated concept of what had to be done. So that is that. And by the way, when you try to acquire those rights, they're not as keen to give you all rights, all sequels, all remakes, and they may not even be able to under their law. Had some very interesting negotiations in Barcelona once on the Gabriel Garcia Marquez novel with his literary agent, who certainly only thought we should get a one-picture license. And even then for only 10 years. So it's way more complicated. 5 is a short one, but something worth noting. A mistake can be ignoring WGA obligation issues and tangled WGA chain of title problems. WGA meaning the Writers Guild of America. I mean, I'm most familiar with US projects where most likely the script is written by a WGA member, and my client is a WGA signatory acquiring that script. However, sometimes there's a sort of tangled line of scripts, multiple scripts. And so then, one really just needs to note whether or not all the scripts are WGA. And if they're not, to see what the agreements, the early agreements that are not WGA say, particularly about credit, because you're going to have to ultimately, if it is obviously quite simple if all the writers are WGA and all the screenplay agreements are WGA and you are a WGA signatory. But sometimes it started with a script that was written by somebody who was not a WGA member, and then it was rewritten by a WGA member. That also can be just fine, provided one should look at what the early agreement says as far as credit and make sure that it will not put you in breach of that, like they haven't been guaranteed credit, which you can't deliver once a Writers Guild, because the Writers Guild controls the credit process. And the other problem, which unfortunately I've seen much messier, is where a script starts with a WGA writer, and then somehow a non-WGA writer was hired, and then a WGA writer, and then a non-WGA. It can be very messy, so you should look for that. That's a pretty small point, but sometimes people skip that. Now we're launching into people. I'm just looking for Q&A. Here we go. Here's some questions already. I'll come back to them in a sec. Number 6, and I think I did ask for just the list of these to be distributed. So hopefully you have this. This is a sort of a bigger one, and it deals with, and you may have some questions about this, not yet, is about life rights. And I say the mistake is often signing a restrictive life rights agreement if you don't really need them. And here, first of all, this is a lot of people will have heard this, that there's not actually something called, there's not a legal right called life rights. It is just a way people describe an agreement that a producer might have with a real person to obtain the right to portray that person and their story in a motion picture. What that agreement really is primarily a waiver or a release of claims. It's, hi, you can tell my story, and I'm going to agree that I'm not going to sue you for defamation or libel or invasion of privacy or rights of publicity. However you tell my story, even if you fictionalize my story, even if you make up parts of my story that didn't really happen, all of those things are fine. So it's a release from liability. It can be other things as well. It's a consulting agreement in the sense that I'm going to tell you my story. I'm going to give you information you don't have. So that's valuable. I'm going to cooperate. I'm going to help by introducing you to other people who can give you more information and maybe give you releases as well. And so it's more, and it's a bundle of rights you're obtaining from them. You might also obtain, probably you will, if you do enter into one of these agreements, a certain degree of exclusivity. In other words, the person will promise not to sell the same rights or give the same waivers or share the same information with anybody else. And therefore you have tied them up, and hopefully, that's going to assist you in making that story. Now, of course, what that also does is, if that person, particularly if they're a public figure, which they probably are, because it's probably an interesting story, somebody else can make that story without those rights. So you often have competing projects about the same person. One producer might have the life rights and the other might not. Usually the person with the life rights agreement is going to be advantaged. What I'm warning against here is, don't sign an agreement where you give that person approvals or, restrictive, like you can't talk about this part of my life, or you can't, because that's going to actually disadvantage you potentially, particularly if there is a competing project. So beware. Maybe you don't need that agreement. Now, part of the reason, when I first started in the business, we had a client who made television movies for networks, and they wanted to make a movie about Liberace. And at that time, networks would not make, these kind of things unless they had some underlying work. They really wanted a life rights agreement or the rights to an autobiography or something. And I remember our client could not obtain any of those things, and they ended up buying Liberace's coffee table book about all the objects in his house, and that had to be good enough. And really, that was nothing to do with you, whether or not you needed those rights. It was just the network felt more comfortable if you actually owned some rights. One of the things they really were trying to guard against was that somebody else would get those rights and make it. So, I did have an agreement that I negotiated for quite a while with the widow of a super famous person who will remain nameless. But that person, the widow, wanted real approval rights, not over the final film, but certainly of the initial script and treatment at various stages. And there was a feeling by the producer we represented in the end, even though it was a coup to obtain those rights and access to all the memorabilia and information and so on, it was thought that it would end up being a kind of hagiography or very saintly telling of the story of this really extraordinary and very good person. And our producer client did not go through with it, but somebody else did, and that film was made and was really quite successful. But it was indeed a film that portrayed that person in a very good light, including, you know, I guess brushing over some marital difficulties they had had. So that was not in it. And that was what the widow wanted, of course. So you just have to know what you're getting into. One other thing is, you know, I'm not discouraging you from getting life rights or other releases when it is advisable or where it will benefit you and where there are not approvals and restrictions. And one last comment about me saying, well, you don't need the rights because we have the First Amendment, you can tell the story and so on, is be very careful about biopics where the subject of the biopic is in fact an artist of some kind, because there will be copyrights that you need in order to tell that story accurately. In other words, if that person is a writer, you might want to quote extensively from their works. If that person is an artist, you might want to show their paintings or show them painting their paintings, or photographs, or if they're a photographer. Musical performers are a big one because you want to be able to show them singing the songs they wrote. Maybe you want to be able to play the recordings they recorded. And often those are rights that you can obtain when you enter into a general life rights agreement, either with the person in question or the estate of the person in question. I mean, we've had so many biopics like the Queen biopic and what have you. And if you don't have cooperation, I mean, it can be very difficult to get the music rights. They don't always, the artist doesn't always control all of the music rights. Maybe there's a music publisher, maybe there's a record company that owns the sound recordings, but you really need those rights. Or sometimes you can just get the musical compositions and then you can re-record the music. But that's a very, I've had so many ugly situations where people have developed entire projects without sort of realizing that they won't be able to show the photographs the photographer took, or, you know, the paintings, the artist. I mean, Picasso estate, particularly difficult. A lot of photographers' estates. I mean, you can if you go out and get those rights, but what if they don't want to give them to you? Lot to be said about life story rights and real basing things on real stories. I'll look at some of the questions and maybe we'll have some questions there. You know, sometimes, one last thing I'll mention, if you are basing a story on real life facts, and even if you're doing it without acquiring rights from anyone, doing it from public domain, you want to familiarize yourself with something called script annotation notes. You can get them from a lawyer, and they're on basically any writer you have who's writing a story. You want them to follow this guide to, when they hand in the script, they've got to tell you where they got certain scenes from, what they based them on, what information, and you're going to want to keep and collect the research as well. If you want to base a story or a script on something that's factual, sometimes what you end up optioning is a magazine article about events. And you have to realize that that's good. It sort of gives you something to work with. It's almost like the research is done with for you, because that journalist is going to be now your consultant. But if it's about somebody, you don't have necessarily the rights of the person depicted. So you might want rights from them as well. So there's layers on this. Let me have a look at the questions. see if any of them, okay, I'll come back to these at the end, I think. Okay, number 7 is failure to be aware of or understand copyright termination. Now, US copyright termination, this isn't going to come up all the time, but it is something that a lot of people are just not aware of, so I felt it was important to mention it. So under the US Copyright Act, and this only applies to the US, and obviously you're making a project for the world, but if you can't show it in the US, that's going to be very significant. So this will apply if your chain of title relies on a license or a grant from an author of a work some time ago. So sometimes you're acquiring rights to do a sequel or a remake of an old picture. Let's say it's a motion picture. And the chain of title is going to start, perhaps it starts with a novel. The author wrote a novel, the author granted the rights to make a motion picture based on that novel to produce a number 1. But maybe he or she did that 30 years ago. And they made the film and they granted all rights to that person. If you read the document, it says, okay, well, the producer has all the rights. They have the remake rights, they have the sequel rights and everything. So I'm going to acquire those from that producer. But what you don't necessarily realize, unless you're familiar with, is that under the US Copyright Act, there are various rights to terminate grants. And the one that is probably most relevant today for works that were written after 1978 is called Section 203. And it's a little complicated. There are tables. If you look up under the US Copyright Office, I mean, you should, if you have an old chain of title that goes back to any kind of copyright work older than a few years ago, you should look at this and just make sure that you're aware of it. It doesn't actually necessarily mean you cannot acquire it. You just have to realize that the risk exists that at some time in the future, the author or the heirs of the author, if the author dies, might have the right to terminate that underlying grant. And if you make a film in the meantime, you will still be able to distribute that film forever, but you won't have any rights to make a remake or sequel after they terminate it. So it is something that relates very much to any chain of title that has older grants in it from an author. And honestly, it can apply to a screenplay too. It's not just a novel. It can be any kind of work where the original grant from the author is from some time ago, and you're relying on that. A screenwriter who writes a screenplay and then sells it to a producer, it can govern that too. What it doesn't cover is works for hire. And so if Warner Brothers hired a writer to write a script, and now Warner Brothers is selling you, and they made a film, the right to make a remake, this will not apply because it does not apply to works for hire. But this is very important for, franchise type properties, or it's important for you to understand anyway, but I mean, it's really important for franchise properties. I've had a lot of issues come up under this where, original grants were made in, I mean, it doesn't even sound that long ago, 1990, 1995. And when you acquire the right to remake a film that relies on a grant from an author from 1995, you have to realize that there will be a 5-year window for termination by that author or their heirs that will come up, 35 years to 40 years from that grant. So here we are in 2021. If a grant was made in 1993, then in a few years, there'll be an opportunity for that underlying rights holder to terminate it. So it's fairly technical. You should be aware of what it is. And if you have any old chain of title, you need to specifically, because not every lawyer is as au fait with this as they should be, ask whether there are any termination rights in that chain of title. So that's pretty technical, but something that perhaps people aren't so familiar with. Okay, number 8, failure to obtain a script clearance report and monitor for clearance additional material added in the production process. So here we're talking about getting much closer to the actual production of the film. We're not talking about the original, the early chain of title. We're about to, pre-production, about to make it. So there are various companies, and, if anyone needs the names of these companies, I'm happy to obtain, to send some of them to you, that will do something called a script clearance report. And a script clearance report is, they read the script and they highlight everything that needs to be checked, and they check certain things. And they're checking for things that you might not think about. If there is a telephone number in the script, if there is a name in the script, they're checking to see whether there are real people who have that name, real people who have that phone number, because you don't want to get, somebody who claims, like, you called me Ralph Hodgson, I'm Ralph Hodgson, you have a character called Ralph Hodgson who is a criminal, and he lives in Brooklyn, I live in Brooklyn, I look like, I'm that age, I live in a house that it seems you're talking about me. It's to avoid those sort of problems. And it's sort of bread and potatoes. They will highlight every product used, every address used, and remind you that you have to consider whether you're going to clear products, trademarks, all sorts of things, and which leads to the next part of this mistake. Now, indie films often don't get script clearance reports because they just don't want to spend the money. It's an extra $1,500, $2,000, and they think, well, I can check this. I go on the internet, check it, and do it. Obviously, it's better if you can afford to have a script clearance report. Then other people hire a clearance specialist sometimes to actually clear the different products and so on used in the production. Studios might have somebody on staff who does that. Perhaps the production designer will be delegated to somebody in their department to do that. And what I'm talking about here is things that get added in the production process, not necessarily just in the script. The script clearance report might highlight a lot of things that you need to check and make sure that when you use this, the script clearance report will highlight a scene which it says, in the background, a news report is showing violence in, Tennessee in 1962. And so the script clearance report will say, need to clear video clip. The script might say, the character drinks a beer, or it might say the character drinks a Budweiser, and the script clearance report will highlight that. But it is the job of whoever is doing the clearances to actually clear that product, clear those video clips, clear that location, clear that, signs with trademarks on it, and so on. Now, there's a whole heap of law about what needs to be cleared and what doesn't need to be cleared, what is fair use, what isn't. But the first step is to know what you need to focus on. Then it's to know, if you're making a movie for Warner Brothers, they will, or any studio or big company, they will require that everything is cleared with a written clearance. That is a very cautious approach. If you're making an indie film, you may, with the assistance of your lawyer, make some decisions about things that don't really need to be cleared. but you'll have to do that in consultation with them to make sure that you don't get into trouble, because some things really must be cleared. Others are in the category where you can argue fair use. You certainly have, I mean, big generalizations. You have to be very careful about using trademarks, business names, or whatever, where the use in the film is not the use for which it was intended and is somehow derogatory. In other words, if you show somebody drinking a can of Coca-Cola and they immediately keel over and die, that's something that perhaps you should think about. How can you clear it in some way? Maybe you can't, but that's, more problematic. There are other things that really do have, and then there are ways of obtaining music and video clips and things from libraries which are pre-cleared. Another thing that, really the production designer should know, but any use of artworks in the set dressing, paintings, sculptures, photographs, any kind of types of work like that really need to be cleared. Again, often, I've worked on lots of indie films. My husband is an indie filmmaker. My daughter's a cinematographer, so I know it from the other end as well. Often the production designer uses their own artworks because they can give clearance because they are the author of it. One area that can be, often comes up, funnily enough, is just photos of characters in the film. They want to have a photo of when they're a child, and the actor often brings in a photo of when they were a child. And, there's often a discussion about who the photographer is, because there is actually a copyright in that photograph. So, I mean, I could go on and on about these, but I won't. But, there is also infringement issues with production design. Those are very hard to know. You're going to rely on your agreements with all of your crew members, which will be works for hire, where they will rep and warrant that they're not going to use any infringing works, and they're going to, hopefully they won't. But there have been cases where production designers base their production design on an artwork and get sued, and the company gets sued for infringement. It's going to be hard to protect against that, but you certainly do need everybody who participates in the film is obviously going to have an agreement that includes reps and warranties about the originality of contributions and the fact that those people are providing it as work for hire. Music, I would just mention music. It's one of my favorite areas for problems. Music is very problematic because you absolutely need whenever you add music to a film, if it is pre-existing music, you're going to need a sync license for the composition itself, the musical composition, and a master use license for the sound recording of that composition. And, that's when you add it later, and you can make sure you get those before you add it. But you are going to have to, much more of an issue, if there's any music that is going to have to be filmed. In other words, it's on camera. Say you have a band performing in the film, you're going to have to get all of that lined up prior to you filming it, or else you're going to have a big problem. And one last thing, in your actor agreements, you're going to want to own all the results and proceeds of their work, and your lawyers should make sure that that includes anything that they create, because if they improvise music and they're playing music, if you didn't put music in it, you're going to have to go and get some kind of license from them. Like, did you write that music? Honestly, we had a real problem once where a very famous actor on an indie film sat down at the piano and played the piano. And we thought, oh, it's fine. We have rights, including music, for things he composed. Turns out it was actually an Eric Satie piece that he was playing, and it was still in copyright. So we had to go after the fact and paid a lot of money to get a license for that music or exclude it. Number 9. Oh, what happened? Something happened here. Oh, here I'm back. Sorry, I I think I pressed the wrong button. Number 9, how are we going for time? Because I want to answer the questions. Oh, we have time. So number 9, this is something you probably won't think of, but delaying obtaining E&O insurance when it could be helpful if it's obtained early. So most of you will be familiar with the concept of E&O insurance, or which is short for errors and omissions insurance. This is the insurance that you obtain to insure against lawsuits from people claiming copyright infringement and the like on your work. Independent filmmakers, I mean, the fact is you always have to obtain this prior to release because your distributors that you license the film to are going to require that you have it. If you're a real indie filmmaker and you're making your film with private money, often you will not obtain the E&O insurance until you've completed the film. There are certain risks involved in that, and sometimes just financially you can't afford it because E&O is not cheap. And you have, if you have a very simple chain of title and it's all sewn up and it's all recorded and so on, that's probably not going to be a problem. It's only a problem if a claim arises before you obtain it. Then you're going to have a real problem obtaining it, or you're going to be able to obtain it but excluding a particular claim. But what I'm talking about is sometimes it's not good to delay obtaining it when it can be helpful to obtain it. And what I'm talking about there is if you know you have a problem area in your chain of title, it may be that one way to solve the problems you have in your chain of title, solve the problems you'll have when you have to present it to any of those people that I said need to know that the chain of title is good, is to obtain E&O insurance earlier. And, then what are some of the problems that I'm really talking about? Well, I can think of one example I had with a producer who had a story based on real facts. They did obtain the rights in a book written by one of the participants in the facts, and which was great because they were cleared from claims from that participant. And also that participant was the lawyer in the law. It involved a lawsuit and therefore, was fairly reliable on the facts. But the producer did not have any kind of waiver from any of the people involved in the lawsuit, either the alleged, in this case, would-be murderer, the alleged victim, family members, and so on and so forth. So, and some of the things in the story, while perhaps defensible because of a lawsuit, were going to be, potentially defamatory. And so what the producer did was obtain an E&O policy early on when they first wrote the script so that they could proceed. And it had knowing that the script had been blessed. It was a very long process to go through it and to analyze each potentially defamatory claim in the suit. And by the way, it was a very interesting process after it was obtained once they were shooting, because if the screenwriter wanted to change a line, it had to go back to the insurer and we had to read it to them and we had to explain how, it could be defensible. Now, that insurance policy was quite expensive, and because of the risks involved, it had a high deductible. Insurance policy, any insurance policy for production, and there are many types, of course, for liability and so on as well, will have different features. One will be like, who is the insurer? Is it a quality insurer that people will accept? It will have a premium, which, if it is a risk if there is a serious risk involved, will be much higher than normal. It will have a deductible, meaning that is that the insured must cover the first X dollars of defense claims before, and that could, where it's a risky policy, it might only be $10,000 normally, or 15 or 20. It might be $100,000 because there's a much higher risk. And then there's the amount of the policy covers, and there are usually two amounts in that. One is a single claim maximum, and the other is an aggregate claim maximum. And distributors usually used to want $1 million for a single claim and $3 million in aggregate. Now you usually see 3 million and 5 million is what distributors want. And so obtaining E&O insurance early can be a way to solve a problem. Perhaps there's some link in the chain of title that's not clear exactly, and you need to go to but you think it's all right, you've got a legal opinion about it, you might be able to obtain insurance that might help you convince your financier later that your chain of title is good. So think about when you're going to obtain E&O insurance. Now, the other thing I will mention is that if you're a bigger company, you may be okay because you may have umbrella coverage, which it means all your company's projects are already automatically covered during the development process. But an individual producer is usually not going to have that kind of coverage, and they're going to be obtaining their E&O coverage project by project. Another issue about obtaining it early is how long it lasts. They usually, when you sell your film, you're probably going to need 3 years coverage. So if you do obtain it early, you're going to have to extend it, and there will be additional costs involved. And you will need a lawyer to vet the chain of title for the E&O insurer and to sign the application. So that is a mistake made about E&O insurance. I have number 10, which I'm not really going to talk about too much other than to tell you to get a lawyer if you have any of these problems. I'm talking about failure to be sensitive to laws and prohibitions concerning government secrets, whistleblowers, obtaining rights from convicted criminals about their crimes. These are all different things, but they're essentially just highlighting to you that if your story is coming from someone who was inside the CIA, who's telling you a story about government malfeasance or what have you, if you're getting your information from a whistleblower who is potentially, breaching all sorts of employment confidentiality and so on, you might well need extra legal counsel to make sure that you don't trip on any of the tripwires around these areas. I'm not saying you can't make those, tell those stories. And, we're very fortunate in this country to have the First Amendment. Some people don't agree, but I happen to think we're fortunate to have the First Amendment. A lot of these issues can be balanced with the First Amendment, but you need a lawyer who specializes and knows the area, before you sign up to make a film based on, facts that may be top secret, that may be subject to all sorts of claims from the government that things cannot be disclosed, and you do not want to be in the position where the producer themselves may be guilty of a crime. Obtaining rights from convicted criminals about their crimes, sensitive area. Many states have some form of legislation prohibiting the payment of money to particularly crimes that have a victim. Some of you will remember the Son of Sam law in New York, where there was a substantial payment to that notorious murderer, and there was a public outcry, and that law was put into place. Many of these laws are then challenged on constitutional grounds and sometimes overturned. But, I don't think it's very common for people to want to pay convicted criminals with, particularly those with crimes with victims money. But, if you are thinking of doing that, I would consult a lawyer. So those were the 10, they were my 10 mistakes. There are many others you can make, but why don't I now try to address some of the questions I see here. Where did I'm going from the bottom. Where did I get my list of 10? I made it up. Okay, number 1. How do you provide chain of title for your own original work, especially if you're not in the US and there's no official place to register your work? Well, you don't have to worry too much if you are the sole author of your original work. Say you've written a screenplay. When you come to, work with a US producer, you will be able to give a certificate of authorship that says, I am the sole author of this screenplay, and you will be able to register it in the US Copyright Office, even if you're not even if you're not in the US. And they will give you a form to sign, and then they will, your producer here may option your work, and then you will represent and warrant to them. They'll just ask you to sign something which says, I am the original author. I didn't base it on anything. I made it all up, and I am granting you these rights. And then you can register it in your name in the US Copyright Office. So that will actually be relatively simple. If you've based it on something else, you'll need to acquire those rights. That'll be a little more complicated. And here's another question that might relate to that. Kevin asks, I have written a screenplay with a collaborator on a handshake deal of 51-49% split of screenplay revenue. My collaborator died. What do I need to get from her estate handled by her children? Well, this is why it is good to have some kind of written agreement when you collaborate with someone to write a screenplay. You basically need to go to the to go to the estate and to their legal representative and enter into an agreement, either acquiring the rights of that person or an agreement where they grant you exclusive right to deal with the rights, and you simply promise that you will do X and Y. Like, if I make it, I will, and whatever I make, I will give you 49% of it as a writer. You need to spell out exactly what you're going to do, but you want to get their exclusive rights to deal with it, because right now they own your former partner's rights. Okay, next question. How do you solve chain of title, a 3-person project? Script, one of whom is the producer who needs to produce and raise funds for the project. Thanks. Well, now, I'm not quite sure what this question is, Kahinde, but I think what it probably is there are 3 people involved in a project. And one is the producer who needs to produce and raise the funds for the project. One might be the screenwriter. One might be perhaps a director. So you all have to reach an agreement as to how you are moving forward. And that agreement can, in fact, take different forms. Sometimes, if it's an independent project and nobody wants to pay anybody anything, you can enter into a kind of partnership where you all agree the 3 of you will proceed together, and this is how the rights, how the revenues will be dealt with, etc. That's a little unusual, because particularly if there is one screenwriter who came up with a project, that screenwriter and it's original, may not want to give those rights to the producer and the director forever. So perhaps that screenwriter will option those rights to the producer and director for a period of time. There's many ways in which to move forward. You have to decide who's doing what and how long everybody's going to have to make it work and who gets paid what. I'm sorry, that's not a very clear answer because there's so many possibilities on ways to move forward. There's also something called an attachment or a shopping agreement. In other words, the screenwriter maybe has written a script all by themselves, could attach the producer and the director for 12 months, for 18 months exclusively to raise the money, and on the grounds that they will each of them make an agreement and they'll work together to do that if that person finds the money. That may not be satisfactory to the producer because they say, I'm not going to work for 12 months, raise all the money, and then you say, I want $1 million for my script. So it is complicated. Next one, anonymous. If I optioned a story that is based on true events, do I have to get life rights of all the living people in the book? Well, this I think I addressed a little bit, but a story is based on in the book. So it sounds like it could be a magazine story, it could be a book, maybe it's a book, maybe it's a non-fiction book, maybe based on true events. And the answer to that is no, you do not have to get life rights of all of the living people in the book. That is really the answer. But you might want to look at, talk to the author of the book, see what context they have, see if there is someone whose story is very controversial, and think about whether or not you want to approach that person and get some rights. Who are the reputable companies that do clearance for indie producers' projects? So this is from someone. I think that what I should do is provide a list of companies, and it'll take me a day or two to put that together. And I can either send it, if you want to send me an email, the person who sent me this question, or I can also send it to Aaron, who could distribute it to everyone who's listening if he wants to do that. But I'm happy to do that. I know some of them off the top of my head, but I would like to list a number of choices for you. Okay, anonymous. If I had purchased the painting of the artist, wouldn't that mean I own it and therefore would not need to get approval to use in my film? Now, this is a very interesting question because the answer to this is no, not necessarily, and probably not, because there are two things. When you purchase a painting, there are actually two rights that you're talking about. You're talking about the physical painting, and you're talking about the copyright in the image of the painting. Most artists retain, when you buy from an artist, if you have a written agreement, sometimes this is actually dealt with in the agreement, you do not necessarily buy the right to reproduce the painting, and it is not assumed that you would have that right. So if you buy a Picasso, you do not buy the right to print posters of that Picasso necessarily, unless you specifically negotiate for that right. There are organizations where you can obtain rights to reproduce works of particular artists, but that's a bigger question, but that's an interesting question. Next one. How are stories based on true stories handled? I can obtain life rights from the main character, but how to handle secondary characters of whom we do not have contact? Well, yes. This is back to my life story rights. It's very interesting because in films about real people, often when there are lawsuits, they do come from the secondary characters. That does not mean that you need to obtain the rights of every secondary character, but what it does mean is that when you write the script or when you have the script written, and you have to have your lawyers look very carefully at the annotation guide prepared by the screenwriter at those secondary characters, because the main character of the story is often going to be someone that, you know, maybe it's a famous person, maybe everyone knows about that person, or maybe they only know about them because of something that happened in their life that got a lot of public attention. But often the characters who people forget about are the ex-wives, the children and those people. And so often the claims come from those people, like, you portrayed me as unfaithful. You portrayed me as a wife beater. You portrayed me, because often those are the dramatic things. And because what happens is you have the life rights. In other words, you have clearance from the main person, and you can show the main person as having flaws, and maybe even the main person is a liar. But you're not worried because you have a complete release from that person. But if you want to amp up the drama, and you want to perhaps show their ex-girlfriend or boyfriend as somebody who abused them physically or mentally or emotionally, that person may have a claim because maybe you created that. Maybe you don't have a basis for it. Okay. I think I've answered the painting one. Where did I get the list of 10? Yes, I answered that. I made it up. Do I have to keep renewing music licenses in my films? That depends on the terms of the music licenses. In the US, when we clear music for a film, if we have, as I said, usually the 2 licenses, the sync for the composition and the master use for the recording. I mean, there may be more than one sync license, because if there are more than one owner of the music composition, like a couple of, sometimes there's a music publisher in the US and one for the rest of the world. But if there are 2 licenses, in the US, we always try to get licenses which are for all media now known or hereafter created for the future. Increasingly, we use the word universe, because now we have Elon Musk and Jeff Bezos and everyone in space. Pretty soon, we're going to be showing movies up in the space stations. So in the universe, in perpetuity. In perpetuity is at least for the life of the copyright of those music licenses. So unfortunately, you have to look at your music licenses. It is less common outside the US to be able to get those very broad in perpetuity licenses. Some people, get festival licenses first, which, they certainly have to be renewed, because those are only to show it in festivals and then perhaps to sell the film, and then you want to be able to get them. So you just have to read your licenses, I'm afraid. Hopefully not, because hopefully you did get perpetuity licenses. Nina asked, you mentioned franchise. What does this actually mean? What are the benefits and downturns? Do we register project script as a franchise? Oh, okay. Sorry, I might have been a bit confusing then. So here, when I was talking about a franchise, that's actually, it's not a legal term. It's just, it's a term used for movies which have multiple sequel potential. So Godfather was Godfather 1, then there was Godfather 2, then there was Godfather 3. You probably wouldn't call that a franchise, a little bit high art, but Spider-Man is a franchise. There are multiple Spider-Mans. Halloween is a franchise. I think we're up to Halloween 11, just released now. That is a franchise. So a franchise tends to be a reference to genre type of films, which from the get-go hoped to have franchise potential. Now, if they're unsuccessful, there's unlikely to be sequels and remakes and so on. But Fast and Furious is an incredibly successful franchise, as is the Saw franchise, as are many horror film franchises. Maybe the first film when they made the first film, they didn't think it was going to be a franchise. But a franchise is really just a term for genre films which are hoped to and intended to have potential. So there's no special way to register them. It's just that if you are making a film, if you are a producer making a film that you think could be the basis of a franchise, you really want to vet your chain of title carefully. Make sure you have as many rights. Hopefully, it's based on an original screenplay and you can have a writer write that so as a work for hire for you, so that you own all rights forever in that and can make these franchise films. You can make plays based on it. You can make musicals based on it, and so on and so forth. If your work is a genre type work that has franchise potential, but is based on something else, like a comic book or like a graphic novel, you just want to make sure that you get as many rights as you can, and that you do get the right to make remakes and sequels and have all the ancillary rights that you can get. That's all I'm saying. There's no special way to register it, which was the question. It's more that you just want to be conscious of what the possibilities are. MK asks, can you review again how to get rights for music for your film from the Central Clearinghouse of Music Rights? Well, unfortunately, there is no Central Clearinghouse of Music Rights for music used in feature films. Not just feature films, but if you have a film and you want to use music in it, there are two ways to get the right. I think what you're referring to, I know what you're referring to now. So you can hire a composer to write a score for your film, and you can do that as a work for hire. And if you do that with your composer, and your composer is also has the job of recording that score and creating a sound recording or a master sound recording for you, you can do that in a contract whereby you as the producer own the copyright in the music, own the copyright in the sound recording. Then you will control that music. You may have to pay some royalties to that composer if you put it on a soundtrack album. You may have to pay performing rights payments, which are organized through performing rights associations. But you will have a lot of control over that music. The other type of music you can put in your film is adding existing music, like music cues, they call them. Like, you know, when you're making a film set in the 1960s and you want to use a bunch of, you know, Rolling Stones songs and stuff, it's going to cost you a lot of money, but you can license that music for that use. And you have to go to the music publisher who controls that music, and you have to go to the record company or whoever owns the master and license that into your production. And it'll be just for that cue. It'll appear like you have, you know, 30 seconds of that song or whatever it is. And you're going to go to them. I think what an Anonymous was what the question was referring to was, I said that there are places that libraries that you can obtain clips and music from that's pre-cleared. And it's not a central clearinghouse, it's companies that create a library of music cues that can be used. And they're, you know, less expensive than going for big, well-known music. And if you can't afford, so I can get some names of companies like that for you. But that's sort of a cheaper way of obtaining music for your film that is pre-cleared. You have to be sure it's a reliable company and they really do own outright that music. Okay. For stories about public people who are no longer alive, do we need to get rights from the descendants or the estate? This is a question about I think about rights of publicity, which is particularly a US concept where, you know, there's something called rights of privacy, but there's also something called rights of publicity. And this is the right to the commercial exploitation of the name, image, likeness, persona of people who are alive, But various states of the United States have laws which have extended this right beyond death, and therefore the descendants or the estate, or sometimes a commercial organization who's purchased the rights from the descendant or the estate, has those rights. So, you know, I think one of the first laws was in Tennessee with Elvis Presley estate. So, I mean, those rights, you may or may not need them to make a film about somebody. You know, that is an analysis that has to be done. You know, you're more likely to need them. For example, if you want to make a commercial for Apple Music and you want to use James Dean, you're going to need those rights of publicity. If you want to make a film about James Dean, you don't need rights of publicity to make that story. You're going to have to be careful with advertising and things of that nature. Again, I'm afraid a lawyer might be helpful. Where can I be contacted? I think my contact details are on the list I circulated. Anonymous, do we need to, and Aaron would have them for you also, Catherine. Do we need to get life rights aside from release for documentaries? A documentary question. Very good. Again, no. And you have more freedom almost in the area of documentaries to portray people because it's in the public interest and so on. But again, your rights to, why would you need them? It's more if you want their cooperation. You know, where people will enter into agreements with people is if you're going to make a documentary about a living person and you want to interview that person and have them on camera and you want them to provide you with various materials, like maybe diaries and personal photographs and stuff, you're going to have to enter into some form of collaboration agreement. Okay. So, I mean, I don't know if that answers the question about life rights. You certainly don't need life rights, but it is really about, you know, what you want from that person or the estate of that person. And, you know, I think part of the problem for a documentary filmmaker is they don't want to give rights of review and approval. And, you know, I've done a lot of agreements in the documentary field and, you know, it's a careful navigation. If you really need their cooperation, you may give them some kind of right of review, which is valuable, perhaps, in fact, to correct errors. And you will show them the film, allow them to comment and give it, but you will not promise to change anything. You know, you'll leave it up to you. Whether or not you change it. But, you know, sometimes people won't agree to that. But you definitely do not need them. You may want them. Okay, ASCAP, I'm not, question mark. What is ASCAP? Well, it is a performing rights association. So there are a number of them. There is BMI, there's ASCAP. So these are basically organizations which rights holders in music, publishing companies for writers of compositions join, and they collect performing royalties on behalf of their members. And so when you create a music cue sheet for your film, you will list all the music cues in your film with the names of the publishers and the names of the authors and the names of the songs and precisely how much is used of that song. And you will give this to the distributor, and the distributor, because performing rights are paid on certain exploitation of a certain type. So when if the film is shown on television, performing rights are covered by a blanket performing rights license that television network has. They pay money to the different performing rights associations, and they calculate how much each of their members is entitled to, and they pay them. So I don't know. The question was, I guess, what is ASCAP? That's what it is. And it's an American one. There are ones overseas. But you cannot obtain the right to use music in a film from ASCAP. Okay, Kevin, my project is about a person who died in 1930. I've taken dialogue from magazines, biographies, and autobiographies. If I can't get the rights, can I paraphrase the dialogue but not use the copyrighted words? Yes, basically. I mean, you need some advice about how to do this, and it depends. But essentially, the answer is yes. But you know, there's a variety of things that are referenced there. You say dialogue. So, you know, again, I'm not sure if you know, what exactly you're talking about. If that person is a writer, you know, they died in 1930, copyright, 70 years, maybe it's out of copyright. Yeah, I think the answer is generally yes, but I would consult a lawyer about exactly where you're taking it from and what exactly it is. And that is the last question I have. Now I have a chat here. I haven't looked at that. Hello. These are just nice. Are there more questions in here? I'm a little confused. I'm not sure if there are questions. Is here? I don't think so. If there are any other questions, maybe you can put it in the Q&A. All right, here's one last question, and I think that might be it for me. If I change my film's title, would that affect the releases and approvals I had already gotten? No, I mean, as long as you have a way to identify that that is the film that they gave the license, the release for. I mean, it is a good reason why you should always say, have a bit of a description, like my my documentary film about, you know, the crash of the airliner in the Hudson, currently entitled Jetliner. But if you just called it Jetliner and now it's called Crash in the Hudson, if you can identify it's the same documentary, you should be okay. All right, last question. If I'm doing a documentary with my aunt, her daughter was in a coma for 16 years, do I need collaboration agreement? I mean, the answer here is that if you're doing, yeah, I mean, it sounds like it, yes, because you're working with her, she's going to appear in it. You don't want her to later on say she never authorized you to do it, or you had an agreement that she would have approval. So yes is the best idea, even though she's your aunt. Oh, they keep coming. Quickly. If I commission someone to write a screenplay for me and I'm not happy with it and decide to do it myself, what should I do? Well, if you have a good agreement, you should be fine. But you have to read your agreement. If you commission somebody to write a screenplay as a work for hire, you paid them for it, and you have the right to change it and rewrite it and do all those good things, you can just rewrite it. What you have to pay them depends on what your agreement with them says. So if you don't have a good agreement, then you may have to go back to them and come up with some kind of settlement agreement with them to make sure that you can do that. But hopefully the agreement you signed allows you to do that. Do I need to re-register my copyright at the Copyright Office and with the WGA if I change the title and revise the story? It's generally wise to do that. You can just do an amendment if it's just a change of title, but you can re-register the new draft. I mean, that was actually, it raised the point, when you do a copyright search, that is very important that you look through the chain of title documents that you've been given and you refer to every title it's ever been known as, because they are filed in the title. How did you get started in the business? Okay, this is going to be the last question because I think I'm running out of time. How did I get started in the business? In Australia, a very long time ago in Sydney, I was fortunate right after I left school to get cast in a movie directed by Peter Weir called Picnic at Hanging Rock. And I was one of the main schoolgirls in that film. And so I had the great pleasure of being in a movie as a very young girl, which ended up being very successful. So I fell in love with being in the movie business, but I ended up going to law school. And then I was lucky to get a job at a firm that worked in movies. And my first film I ever worked on, and in that firm as a lawyer, was Mad Max Beyond the Thunderdome. And then I moved to New York and worked at Pryor Cashman. And then I moved to LA, and here I am today. So that's the short version. So thank you very much. And I think that's the end. Aaron's supposed to come in and sort of usher me off the stage, which is actually my office at home, because I'm not in my real office today. And I did promise to send a few things, which I will do. And that's it for me. And thank you very much, everybody.